8 or 7 types of khiyar. What khiyar al-shart or khiyar means, as we said, it's basically the stipulations that would be maybe in the contracts that would give the person the right to return a merchandise or to break the contract, whether it's a merchandise or to break a contract. What are the things that makes breaking the contract, makes it permissible, or makes a person has a choice? He has a choice to break the contract or to continue the contract after the contract obviously is made. Because if the contract is not made, there's no mean of saying this. It's meaning after the contract is signed or after something a person purchased. As we know that this becomes final. البيعان بالخيار ما لم يتفرقا, as the Prophet عليه الصلاة والسلام said. البيعان بالخيار. البيعان, the two sides, the buyer and the seller. بالخيار, that's the word here. They have a choice when they're negotiating, when they're sitting in the majlis, when they're sitting together, talking about what they're going to sell, and he accepts, yes, sure, and he even gives them the money, and all, as long as they're sitting. So they have the khiyar, that means they can break the contract anytime while they're sitting to make the contract, even if it's signed. ما لم يتفرقا, as long as they did not depart from one another. If they depart from one another, then it's final. But there's other things that can be valid for it, for them to break the contract. So if we pay attention, inshallah ta'ala, to these 7 types or 8 types, as some added an 8th one, to understand basically the different types. The first one is khiyarul majlis. It's called khiyar. So the word khiyar, we need to remember this. Khiyar is a word used for cucumber, by the way. In the so it's but khiyar here is from al khiyara, when you, like the word al istikhara, even when you seeking a decision in what is good. So al khiyar here, the choice, basically that you have a choice in the subject of contracts or buying and selling, that the choice to to cancel, to avoid the contract without any consequences, or maybe there might be consequences as a result of that, but the validity of it, that it's not haram, things like this. The first one is what we just talked about, khiyarul majlis. Al majlis is the sitting, and some of it we need to remember the words, inshallah. So khiyarul majlis, can we say khiyarul majlis? No. Khiyar al majlis. Khiyar again is the choice. Al majlis is the gathering. So say for example, yeah, you guys are here and I'm gonna sell you something, right? And we're sitting negotiating, and I have the contract with me, and you agree, we agree to the price, and we're still sitting, right? And I give you the contract, you sign it, and I sign it, you read the contract, and we agreed on the price, and everything is clear. And you sign it, and I give you, each one of you what I'm selling. Say a book, for example. I have books, so I give each one his book, and everybody signed the contract or without contract, right? They give me the money, and they give you the book, and we're all still in the same majlis. You have the right, after all of this is done, to say, I quit. I want my money back. I want this as if nothing happened. You have the right, as long as you're still sitting together. No side, like the seller, for example, would not say, you already signed the contract, I'm sorry. It's already signed, it's over with. No, it's not permissible. As long as you're still together in the same majlis. Once you depart, then it's final. And there are other khiyar, other types can be still valid. We didn't talk about it yet. So khiyarul majlis, the khiyar of there, and there are many questions that you might ask, but we'll keep it like this, inshallah ta'ala. And there is many things that can be fixed with the urf or what's known. For example, if people are sitting together and they depart. If people are walking and they're buying and selling while walking, okay, this and that, once they depart, it's over. If they're sitting in a bus or something and they're buying and selling, once they depart, it's over. If they're on the phone, once the phone the phone line is cut off, then it's over. The same thing online. Once you finish what you're doing and it's done, you hit okay and then you're gone. It's over. Things like this. So this is khayr al-majlis. So as long as the person is still in the majlis. To add to this, a very small point before we go to the second one, unless they would agree once they sit that once the contract is signed, then it's final, even if we're still continuing to be present in the majlis. If they don't make this as an agreement before they sit, then both parties have the right to cancel the contract as long as they're still sitting. Okay, so if someone knows this ruling, so once he sit with the buyer to sell something, you tell him, listen, once you sign the contract and we're still sitting, it's final. Don't tell me I need to take it back. And if he agrees, then it's agreed upon. So this is a right that he gave it away. And of course, the wisdom behind that is very clear. Sometimes you want something, but once you purchase it, really, you regret. The feel of it, the effect of it is different. And he didn't do any harm to the seller because you still, as if nothing happened. You did not leave, you're still in the majlis. So this is called khiyar al-majlis. Clear? The second one, they call it khiyar al-shart. Khiyar is easy. The word al-shart is condition, and we talked about conditions before, right? So we have khiyar al-shart. Khiyar al-shart, what is khiyar al-shart? The choice of a condition to be there, which is most of the contracts, for example, you have here, has this. Meaning that you make a condition that you can return the merchandise within a specific period of time. 14 days, 15 days, a month, 3 months, right? You have without any questions asked. This is the second one is without any defects or anything, without any questions asked, or if they ask and you say nothing, they would still take it and they would give you your money back. This is under the category of khiyar al-shart. People can say that, but they have to agree upon it, or it has to be mentioned in the contract, or it's well known. Second one is easy, right? This is what people understand and they do. It's called khiyar al-shart. Inshallah, it's not going to be difficult. You don't have to memorize them all, to list them all, but it's important to know them, inshallah. The third one, it's called khiyar al-ghabn. Khiyar al-ghabn. Al-ghabn. Surah al-taghabun? Right? Al-taghabun means when someone was cheated, or when something that was very, very expensive, and he had a very expensive thing, like for example, as the example that I always give, a diamond that is worth millions, for example. But a child, to him, it's just a piece of glass. So he goes to the candy store, tell him, take this and I want candy in return. Right? So the guy give him candy and he takes the diamond. What happened here? Ghabn happened. That means it's basically, there was cheating here, but it's not necessarily cheating, but it's something that is worth so much was sold for dimes, or the opposite. So this is basically what al-ghabn means. I'm not sure how can you remember that, but there's, if you want to go on with the 3 different types of transactions that they mention under this category. One of which is talaqqi rukban. So a subtitle to this, talaqqi al-rukban, which means when you wait for the caravans or those who are coming from as strangers, and we talked about that before, you go out, you're a resident of a city, and there's people coming to sell their merchandise in the city, and they have no idea what the market is. So you go out before they come in, and you know that the merchandise in the city is worth 10, but they don't know this. So you go out and you take it from them for 1. Right? So this is ghabn, and they didn't know. So they have the right to avoid this. This is a form of cheating. Right? So when something is expensive, then they take it very cheap. The second type is najash, that we talked about it the day before. Remember najash? When someone in bidding in an auction, he bids without the intention of buying. He's just there to increase the price, whether he's hired by the auctioneer or he's just doing it for fun or to annoy someone or whatever. He's not there to purchase, he's just bidding to increase the price. So this is the same thing, ziyadat and najish. And of course, the transaction will be valid unless they get to know that there was some form of a conspiracy there. There's a third point here in this khiyar al-ghabna that is also mentioned. They call him al-mustarsil. Al-mustarsil is the guy that has no experience whatsoever, and he's naive, if it's correct to say, and he can be easily deceived. Have no experience whatsoever, and he goes to purchase something like when you send your child, for example, if you're some parts of the world, you send them with, some money, and you don't have change. So, say for example, you give him $100. You go get some candy that is worth, $5. So he goes there, and the guy sees him that he's not really know much. So he say, "Oh, it's worth 50." And the kid doesn't know the meaning of what 50 and what this, so he give him. And sometimes it might be an adult. And there's a hadith of the Prophet ﷺ. It can be even more complicated than this. Cars, for example, something that is, very expensive. And if you add some money, a person would not pay attention to this. So this is basically, again, what's khiyarul ghabn? Ghabn happened, that means something that was very cheap and he got it very expensive. And what is very expensive versus what's very cheap? The urf, the norm of the people. Something you cannot buy this for that much. A car that it's the price of it and the fair price and the most that for example, they give the car the least is 6 and the highest number is 10, for example, and the guy sell it for 30 or 20. Right? This is then he has the right to return. Islamically, he has the right to return. And the other side should not say, well, he agreed to this. No, you cheated the guy. So this is khiyarul ghab. Clear? This is number 3. And it has to be, again, not that the maximum price is 1,000 and you give him 1,005. No, it has to be something that is very clear. There's some level of loss here. Are you ready for the 4th one? Is it? If it's difficult, it's okay, inshallah. As long as you write it down, inshallah. Number 4, خيار التدليس. خيار التدليس. And if you don't know it in Arabic, it's okay. التدليس. التدليس is something close to the previous one, but it's the deception. When someone deceives someone, but al-ghabn, which is the previous one, is when it really clearly something very expensive and is given very cheap, or vice versa. But at-tadlis is much more general than that. Perception, meaning someone hides a defect in the merchandise. He knows that the car has a defect and he doesn't say it. Or he covers it. Right? He covers it up. It involved in a major accident and he covers it up with, whatever, paint, things like this. So he hides a defect in it. Clear? And also something that he might, and this is one as an example. Another example to this specific khiyarut tadlis deception, all kinds of deceptions can be mentioned here, is a person would do something to the merchandise to increase the price of it. And there's a famous example like that in the books of fiqh, which is tasriyat al-laban fi ad-dar', and the Prophet ﷺ forbade that specifically. When people selling a goat or a cow, right, so they would tie the udder of it, and it collects the milk. So when he goes to the market, it looks, that it gives lots of milk every day, as if he just brought it today and he took the milk yesterday and now this is a new day and this is, mashallah, a very healthy cow that gives lots of milk. When exactly what he did is that he tied it so that it doesn't milk, or he does not milk it so it's big. This is perception. And if the selling or the contract is done, and there's a hadith of the Prophet ﷺ, either the other side would take it and is fine with it, or he has arsh, or that means he has the differences to be given to him. And the Prophet ﷺ said, sa' min tamr, to be given a sa' from dates, like in return for basically this milk that he thought that this is an extra. But anyway, we don't have to know these details as long as it's based on tadlis. Tadlis, whether it's in increasing the price or covering a defect. Okay? Clear? Everybody's following with, am I going too fast? طيب. Number 5, خيار العيب. خيار العيب, and العيب is a defect also. But this is a specific one. When it comes to the defect is something wrong with whatever a person purchased, and it's only to be known by those who are experts. So this is different than covering a defect. No, the merchandise has a defect in itself. So, and they make it as a separate one. And there's details in this. For example, a person, again, he purchased something, say a car. He purchased it for 10,000 with the condition that everything is functioning. The like of the same car, if it has, for example, the defect, say that they changed the motor, for example. And if he got to know that if the motor was changed, it would have been sold by 7,000. But the guy didn't tell him. Something like this. So he has the right to return it back. And here also, when he has the right, that means he might say, no, I don't want to turn it back, but I want the differences of the money. That's fine. Or the seller would say, no, I'm not going to give you any differences. Just give me the car back and give you the money, right? So if he purchased it for 10 and really it was worth 7. So the experts, if they're in front of a judge, the judge will bring those who are experts in this business, car dealers or whatever there is, and he would ask them, how much is this car worth if it's sound and good? And how much is it worth now because of the defect that it's in it? So if they say it's worth 10 here and because of this defect it's worth 5, so then the choice is given. Either the seller would give him 5 or the seller would say, no, I'll cancel the whole deal, give me the car back. So he has the right to do either or. And also the buyer, he has the right to say, I don't want any differences, I just want to return it. He has the right to do so. So all of that is part of the khiyar of al-ayb. Clear? So this is number 5, which is closer to number 4. But number 4 is more general, which is a tadlis deception, which is the 5th one is clear defect in the merchandise. Number 6, and this is also something that is people, they do these types of transactions, and the murabaha and the like of it come into this category, which is al-khiyar here, fil bay', the khiyar or the choice in the bay' itself, in the contract or the transaction itself, by a person or by the seller specifically mentioning a price. What does that mean? Some form of transactions, the seller would say how much he purchased it with, right? So this is basically what it is. When the seller informs the buyer how much he purchased it with. So you're going to purchase a car and he has the price for it, 10,000. He says to you, I purchased this car for 7,000 and I'm selling it to you for 10,000. The fact that he said, I purchased it for 7,000, there is implications to this. What if he said that and you find out that he was lying? You have the right to return it back. So if he says, he doesn't have to, right? In normal situation, he doesn't have to say how much he purchased it for. And if someone asks, which is also the buyer, he should not ask. It's none of his business. If he asks, how much did you buy this car for that you sent it to me? He doesn't have to tell you. But if he says, I purchased it with that much, and you find out that he was lying, you have the right to return it back if you want to return it back. Right? And this actually, whether they call it a tawliya or a sharika sometimes, somebody asked me this question maybe a couple of days ago, something like this. When you purchase from someone a percentage of his company, for example, or a percentage of his investment, right? So this is, for example, he would say, I'll sell to you 10% of my share in this company. 10% from my share in the company. I'll sell it to you. So that means you get to know how much he has. So he would say 10%, but then you discovered that he really sold to you only 5%. Because when you get to know how much the company is and how much he owns from the company, really he did not sell to you 10, he sold 5. So he said how much. So it has to be, if he says the specific number, that means he has to, you have the right if this number was not there, or the percentage, for example, if it's in the shirka, a sharika or partnership or something like this. And one of the very clear examples in this, al-murabaha. You heard the word murabaha, right? Which is al-murabaha. What's the murabaha means? That some of these so-called Islamic finance companies, they might call that we're selling the car or selling the house with the murabaha system. Murabaha means that you already know the price of the house. So and you come to them, you go look, shop around, and you like a specific house, and it's worth 100,000, for example, and you go to these people and you say to them, this house is for 100,000. Say, okay, we'll purchase it and sell it to you. I'm talking about the halal part. I'm not talking about these companies or whatever. Every company has to have a fatwa by itself. We're not talking about the companies. We're talking about the subject, which is called al-murabaha, which is a permissible means of buying and selling. But the murabaha originally doesn't have this surah or this way that I just mentioned. The murabaha is simply as the seller would say, I purchased this. I purchased it for 10 and I'll sell it to you for 15. That's what al-murabaha is. So if it's discovered later that it wasn't true, then you have the right to return it. Right? And the opposite of al-murabaha from al-ribh. That means he specify his profit. Correct? The opposite of it, they call it al-muwada'a. You don't have to remember also that terminology, but al-muwada'a is the opposite. When someone is selling with a loss, and he says, I purchased it for 10, and I'm selling it for 5. That means he's selling it with loss. Later on, he discovered that it wasn't the case. You have the right to take the difference or to return it or whatever, because he lied. So, clear? And again, murabaha, muwada'a, like this, a person doesn't have to say this. And that's why which is better, is to make it at ease or to make it very tight for oneself. It's up. Sometimes what works is that the person would say, this is how much I purchased it for, especially if people trying to put it down or something. Says, I only purchased it, my profit is this. Things like that. And lying in these things is a major sin, of course. So this is all. Number 6, الخيار في البيع, when the price is mentioned, when the price is specified. Number 7, which is also a very detailed subject in the books of fiqh, we're only taking the titles of things, and each one has so many different masails and things like this. الخيار here, because of الاختلاف or disputes among or between the buyer and the seller. So whenever there's a dispute, how to deal with that dispute? Sometimes there's khiyar here. There's a choice here to either to void the contract or to give differences and things like this. To have an example, if someone, say for example, someone sold something, but the money was not paid. So a person purchased, he sold a car for 50,000. And the guy says, sure, 50,000. I'll give you the money next month, whatever. But the transaction is done. And the money does not make if a person does not pay the money immediately, still the contract is valid. Whether it's payments or even one payment. The money is not the issue of making the contract final. So they made the contract and it's finalized. I'll get you the money next month. Give me a month to bring the money. Sure. But the deal is final, right? And it wasn't written, it was said and things like this. And then later on, they become in a state of dispute. The seller says, I sold it to him for 50. And the buyer says, no, you only sold it to me for 25. So there's a dispute with regards to the price. Of course, if there's evidences or contracts, then the matter is over, right? There's no dispute here, no khiyar, no choice here. So evidence, things are recorded. That's why things should be recorded. But if they didn't record anything, just word of mouth like this, and one says, I sold it with this, and he says, no, you sold it with less. So then what is the deal here? They go to the judge. because one took the car already. It's gone. So they go to the judge. I purchased it for this and that. So the judge, what should he do? He should bring them both. And as long as there's no evidences, you know that al-bayin ala man idda', right? There's the hadith of the Prophet alayhi salatu wasalam, that if someone claims something and it's a false accusation or true accusation, doesn't matter, but he has no evidence, then he has to swear by Allah subhanahu wa ta'ala that what he said is right. And the other side is not acquitted, but the other side has to swear by Allah that he is a liar. Because there's a chance that what he's saying is right. You understand this point is very important, because this is a major difference between the Islamic system of justice versus others. If someone goes to the judge and he says, my neighbor, for example, he stole my car, just like that. Do you have evidence? No. Camera? No. Nothing whatsoever. You have no evidence whatsoever. So the judge, without affecting the neighbor or that person with anything whatsoever, he'll bring them both, and in front of the judge, he would say that your neighbor is accusing you for stealing his car. Either he says, yes, I stole it, please forgive me, or arrest me, whatever. Or if he says, no, I didn't do it. So is that enough for him? Even if there's no evidence? No. This is where the extra part. He has to swear by Allah that he didn't steal it. And if he swears by Allah that he didn't steal his neighbor's car, then there's no case. And nothing, no records of anything. Right? The guy is not accused of anything. There's no evidence of anything. But he has to swear by Allah. And you see the importance of that, because if there's still some deen, because if he swears lying, this is the min ghamuz, this is dips the person in the hellfire. So he might be denying, but then once he's going to swear by Allah that he didn't steal when he did, then maybe there's a chance here that the truth will come out. So, but here in this case, do you understand this concept? But in this case, when there's disputes between the buyer and the seller, when it comes to the price, both they have to swear. Not one, both. So they both have to swear, and the swearing here, the seller has to swear first. This is the system, how it's a very specific, and if the only benefit for us, at least to know that this deen is well established, and there's a very specific ways of dealing with these matters. In front of the judge, the seller would have to swear first. And he has to swear with negation and affirmation. So the seller has to swear first, and he would have to say it in a negating statement first. Like, for example, he says that he sold it for 50,000. And the other guy is saying, I only purchased it for 25. So he has to say, by Allah, I did not sell it to him for 25. By Allah, I sold it to him for 50. Has to be like this. Negating what the other guy is saying and swearing by Allah of what he is saying. So it has to be both. And what comes first? A nafi, or negating, comes first. So it's a very specific way of swearing or taking an oath. So the seller swears first, and it has to be both with negating and affirming, and the negation comes first. And then after that, the seller, the buyer would swear in the same way. That with negation and affirmation, and the negation comes with. He would say, by Allah, I did not purchase it for 50. By Allah, I purchased it for 25. And if both they swearing by Allah, and one is a liar and one is truthful, once that is done in front of the judge, then the contract is void, and the seller gets his car back, or gets whatever is, as if nothing happened. Again, there's no evidence of anything. This is in the case when there's no evidence. Right? So this is 7. Some they add an 8th one, which can be included in the 7 one, if the characteristics or the description of the merchandise is not as it's been described, which is you can put it in the previous ones. Right? Someone sold something over the net, for example, with the specifications of it, and it's not as it's described. So you receive it, and it says it's white, and it's not white, or it's thickness of it, dimensions of it, whatever there is. Right? So it's not according to the specifications that are mentioned, and of course you have the right to return it back. Is it, first of all, is it clear? These 8 types. خيار المجلس, خيار الشرط, that's the time. And time has to be specific, of course. خيار الغبن, which is the price, very expensive versus very cheap. التدليس, deception in general. Covering a defect, increasing the price by doing something, and tying the things to the milk. Number 5 is al-aib, something that is defect, and they can take the difference between both. And the number 6, or specifying the price that the seller purchased it from, purchased it with. So thaman, the price. And this is when it comes to al-murabaha wal-muwada'a, and like these types of things. Al-khiyar of if they have dispute, that's number 7. And if you add number 8, if the description is not according to what they've specified. Is it clear? I'm sorry? The 7th one, they said خيار لاختلاف المتبايعين. خيار لاختلاف بين المتبايعين, or the dispute between the two متبايعين. I see the البيع is, again, we say البيع usually mentioned for selling, but البيع in Arabic refers to both. المتبايعين, those who do بيع, both sides, which is the buyer and the seller. Is it the same, number 7, as the husband and wife, they have zina, and the husband accuses his wife of zina, which is al-mula'ana? It has some resemblance, but of course it's different when it comes to the zina. Then he has to swear by Allah, and she has to deny what he's saying. And if she's swearing by Allah 4 times and then 4 times, and the 5th time, the curse of Allah subhanahu wa ta'ala upon the liar and things like this. And then once they both swear opposite to one another, then the judge will separate between them forever. They cannot be married anymore. No. Should we take the hadith quickly, inshallah? طيب, hadith number 125, and then if you have any questions, inshallah. Hadith 125. And also, if in your notes you don't have 6 examples of forbidden transactions, and then 8 points or 8 categories of al-khiyar, or the choice of avoiding a contract, make sure that you say something so that we add them. It's not in the book, inshallah. So, but let's take first the hadith, inshallah. Hadith 125. Repeat, inshallah. عن ابن عمر رضي الله تعالى عنهما أن رسول الله صلى الله عليه وسلم قال: أمرت أن أقاتل الناس حتى يشهدوا أن لا إله إلا الله وأن محمد رسول الله ويقيموا الصلاة ويؤتوا الزكاة فإذا فعلوا ذلك عصموا مني دماءهم وأموالهم إلا بحق الإسلام وحسابهم على الله تعالى. This is from the 40 hadith of Imam Nawawi. And the hadith, Ibn Umar radiallahu anhu is reporting it, that the Prophet alayhi salatu wasalam, he said, Umirtu an uqatil al-nasa, that means I have been commanded, an uqatil al-nas, to fight the people. And al-nas here refers to only specific category of people. Hatta yashhadu, till they witness that there is no one worthy of worship except Allah, and that Muhammad sallallahu alayhi wasallam is the messenger of Allah. وَيُقِيمُوا الصَّلَاةِ, and they establish the salah, and they give the zakah, وَيُؤْتُوا الزَّكَاةِ فَإِذَا فَعَلُوا ذَلك, and if they do so, عَصَمُوا مِنِّي دِمَاءَهُمْ. عَصَمُوا, al-isma is to be protected from me, their blood and their wealth, وَأَمْوَالَهُمْ إِلَّا بِحَقِّ الْإِسْلَامِ, except with the haqq of al-Islam, except with the right of al-Islam. The right of al-Islam, that means excuse me, if someone would do something after being a Muslim that uh, would then make him responsible for his action, and he has to be punished, like the zina, for example, like stealing, like killing. So if someone became a Muslim and he killed, for example, someone, then he is to be punished, and not to say I'm a Muslim, you don't punish me. So this is the meaning of إلا بحق الإسلام, except with the right of al-Islam. وحسابهم على الله تعالى, and the reckoning is by Allah subhanahu wa ta'ala. He's the one that judge between them in the day of judgment. And this is basically what the hadith says, as we know from the actions of the Prophet ﷺ and the ayat of the Quran. لا إكراه في الدين, there's no compulsion in the religion. And what is meant by this is, and the Prophet ﷺ would have treaty with people. So, الناس here, who are the nas? It's very important to understand the context of things. أمرت أن أقاتل الناس, I was commanded to fight الناس, the people. And Allah subhanahu wa ta'ala says in the Quran, وَلِلَّهِ عَلَى النَّاسِ حِجُّ الْبَيْتِ. It's upon الناس, the people, to make hajj. So الناس here in the ayah, does it mean everyone? No, of course, only the believers. The disbelievers, they don't come for hajj, only the Muslims. So الناس in the ayah refers to the Muslims. So the same thing, الناس here does not refer to the Muslims, because it's a very obvious one. It does not refer to those who have a treaty with the Muslims, because this is to be honored. It only refers to those who are in state of war with them. So they are already in a state of war. There's no treaty between them. So this is what is applied. And this is also talks about jihad al-talab, which is two types of jihad. Jihad al-talab is to go after, to establish the deen of Allah subhanahu wa ta'ala and to initiate, versus a daf', or which is the jihad of defending, which is two types of jihad when it comes to the physical ones by the people of authority. So this is from the 40 hadith of Imam Nawawi rahimahullah.